If you're a recording artist, a songwriter, a fine artist, or a writer of prose, you've likely encountered what's called a work made for hire clause. And that clause in an agreement effectively states that what you're about to create shall be deemed a work made for hire. But if for whatever reason it is not a work for hire, then it is a transfer from the moment of creation. There's a very significant difference between the two and how they're treated under the law. That's what we're going to talk about today. Work for hire arises effectively in two different ways. One is the work of an employee within the scope of their employment. Someone who's a W-2 employee who gets paid a full-time wage to do creative work. It makes sense that the fruits of their labor are owned by the employer. There's another way, however, that a work for hire can arise, and that's if the party that is being commissioned signs a contract in writing in advance of the creation of the work that says it shall be a work made for hire. But that's not even enough. It has to fall within one of 9 categories of works articulated in the Copyright Act. And those include contribution to a collective work, an audiovisual work, and other categories that we don't need to get into for this purpose. Folks in the position of creators would typically prefer that a work be deemed an assignment or transfer or license and not a work made for hire. That really deals with 2 particular issues that came about after the amendment to the Copyright Act in 1976, which was much more user-friendly. The way that the rights are articulated is equivalent to a sort of property right when you're talking about a bundle of sticks. There are all of these sort of different monetization streams that are articulated. You want to make sure if you're the commissioning party that you own them all. If you're the creating party, you want to possibly hold on to as many of those sticks as possible. The other issue relates to something in the Copyright Act, again, which came about as of the 1976 Act, called the termination of transfers or licenses. With respect to the termination of grants or transfers, as opposed to a work made for hire where the author is the commissioning party or the employer, the Copyright Act provides for terminations in certain circumstances. And after 25 years, if it's a transfer or grant, the author can send a notice stating that they're reclaiming those rights at 35 years. Now, when you're creating a work and you're doing a license, 35 years seems like forever ago, and certainly 25 years does. But if you look at someone like Kurt Cobain, for example, who passed in 1994, every single song he's ever written is now subject to a notice of termination. And you think about the value of the Nirvana catalog. And that's really important. Had those songs been created as works made for hire, and I don't know, but had they been, there's no termination of transfer. There's no right to renegotiate and reclaim those works. Because a work made for hire is owned by the employer or the commissioning party from inception, one of the issues I face in my practice all the time is work for hire clauses presented by software developers that say, upon payment in full, at the end of a project, when everything's created, this shall be deemed a work made for hire. The software developer says that because they want to protect themselves to ensure getting paid, but it's impossibility under the Copyright Act. You can't have a transfer become a work made for hire because then it's subject to the termination rights. And work for hire is specifically excluded from those termination rights because it is never owned by the creating party. It is always owned by the employer or the commissioning party from inception.